I don't know sign language, sorry.
I can't read math.
I realized when I'm thinking about that.
Yeah. As I was telling her Rush was that it'll take us into 2022. The amount of stuff we gave her.
Hello.
The point.
Hello, Commissioner. It's Matt
Hello.
Matt Hardigan. We'll be getting started in a
Yeah.
minute.
Yes. That code works. That code works.
Okay, sorry about that. We'll get started in 1 minute.
Thank you.
Thanks.
More likely.
Oh, yeah, no problem at all. I'm here.
Okay.
I'm also going on computer, see if I can see you guys.
Well, it's just me and Gloria, so I don't think we're gonna, I think we're just gonna leave
You're
it.
not going to stream. That's okay. I know how you look, so that's good
No.
enough.
I have a face for, I have a face for radio, so we
Yeah.
won't stream today.
Nice scenery. Come, let me see. Okay, you may not be, I do both. I mean, I open the streaming and I also call on the phone, so.
Can you swap to one of the microphones if you need to speak?
I can see Dallas, is it there? No. Hello?
No, yes, no, Commissioner, you may be looking at an older, an archived, meeting.
Yes, it is archived.
Hey,
You are
Dallas, it's Matt.
right, okay.
Hey, Dallas, it's Matt.
You're right, Matt, you're right.
Good afternoon, Matt, and Commissioner Correa. This is Commissioner Gray. How are you guys this afternoon?
Commissioner Gray, the acting chair, yes, we are doing fine. How are you?
I'm well, thank you very much. It's hot today, but otherwise, not too bad.
Right. 3-4 more days and our life will be beautiful after that.
Still got you. And you're welcome to spend if you want to.
Okay. Oh, we'll wait. Okay, we'll wait. Thanks. Holy smokes. So Dallas is gonna try to join, so we'll give him a minute. Dallas is gonna try to do it.
Are you are
I guess
Okay.
Carol will take over.
Oh, Commissioner Gray?
Yeah.
Oh, okay.
Good afternoon, ladies and gentlemen. This is Commissioner Harold Gray, acting chair. This is the Public Service Commission hearing for August 25th, 2021. I'll start before calling the roll for commissioners to ask if there's anyone on the line who has not muted their device. Please, at this moment, mute your device unless you are speaking. Please mute your devices unless you are speaking. Thank you very much. The commissioners, Commissioner Correa, are you here?
I'm here.
Commissioner Drexler, are you here? Commissioner Drexler, I don't hear you if you're mute. Are you here and present for the meeting, Commissioner Drexler? I don't hear Commissioner Drexler. Commissioner Conaway, are you present today? Commissioner Conaway. I don't hear Commissioner Conaway. You're not on mute. Chair Winslow, are you tied in today with us? Commissioner Winslow?
Commissioner Gray, it's Matt Hartigan.
Yes, Matt?
I did speak to Chairman Winslow earlier, and he did say he was going to attempt to join, so we might give him a minute, and if you'd like, I can step out and try to reach Commissioner Drexler.
That'll be fine. So we're in a delay for a few minutes to see if we've got other commissioners attempting to connect.
Thank you.
Hello? Hello?
Yes, who's speaking, please?
Commissioner Drexler.
Oh, Commissioner Drexler, yes, you're present. So Commissioner Correa and Commissioner Gray are both present. I think Matt Hartigan stepped away to try and reach you, Commissioner Drexler. When he returns, I'll start the agenda.
I believe there was an issue with the access code or something.
Yes,
Okay.
yes.
Hi, Commissioners.
Yes.
I'm back, Commissioner Gray.
Okay, very good.
Thank you.
So we have a quorum. We have Commissioner Drexler, Commissioner Correa, Commissioner Gray are all present. Thank you very much. So the first item on the agenda today, we'll call the meeting to order now. First item on the agenda are the adoption of the meeting minutes. Any commissioner have edits or changes to the minutes? Could I get a motion for adopting the minutes?
I
I'd
move
like to
that
make-
we adopt the, okay, I move that we adopt the minutes of August 4th meeting and the August 5th meeting also.
Thank you,
I
Commissioner
second.
Correa. Thank you, Commissioner Drexler. Any discussion? All right, all those in favor signify by saying aye. Aye.
Aye.
Commissioner Correa,
Aye.
Commissioner Drexler? Thank you.
Aye.
Aye.
I'm here as well.
Is that Chair Winslow?
Yes, I'm here.
Yes, thank you for
Aye.
joining us. So the record will reflect that Chair Winslow is present. Do you, Chair Winslow, want to carry the agenda from this point forward?
No, why don't you do that, in as much as I'm concerned that maybe I'll drop out.
All right, very good. Thank
Unintentionally.
you. Thank you, Chair Winslow. So the next item on the, by the way, Chair Winslow, did we record your vote on the adoption of the minutes before we move from that item? How do you vote?
In favor.
Okay, thank you. Thank you very much. So the next item on the agenda is the consent agenda. Do any commissioners have issues or want to remove any item from the consent agenda?
Chairman Gray, Commissioner Gray,
Yes,
this is Tom Walsh on behalf of staff, and I'm sorry to interject, but number 10 on the consent agenda, staff is requesting that it be removed from today's consent agenda and rescheduled to the Commission's next meeting on September 15th. This is docket 21056 concerning Artesian Waste Management, Inc.'s CPCN, concerning a parcel in Sussex County. And yesterday, the town of Milton filed an opposition, and we thought, in fairness to the parties, and certainly in the interest of the Commission's time and consideration, we should reschedule this to the September 15th meeting. And that is, again, consent number 10. That could be removed from today's agenda, and the parties have been informed and consented to that as well.
All right, very good. Thank you, Mr. Walsh. So, do any commissioners object to the removal of item 10 from the consent agenda? If yes, please speak now. Anyone object to removing item 10? Hearing no objections, it is removed. Mr. Walsh, any commissioner have any other items to remove from the consent agenda? Hearing none, can I get a motion to adopt the consent agenda with the exception of docket 210536?
So moved.
Mr. Acting Chair, so moved.
I did hear
Second.
Chair Winslow move, and I think I heard Commissioner Correa second. Is that correct?
Yes, second, yes.
All right, it's been moved and seconded. Any discussion?
Yes.
Any further discussion? No? All those in favor of adopting the consent agenda, Commissioner Correa?
Aye.
Commissioner Drexler?
Aye.
Chair Winslow?
Aye.
And I also vote aye. Consent agenda is adopted. Next item on the regular agenda is in the matter of the application of Delmarva Power and Light Company's 2021 transmission formula rate, PSC docket number 210482. And who is present to speak on that matter? Just one second, please. Is Ms. Dawn Kurtz-Crompton from Delmarva Power present?
Yes, good afternoon, Acting Chair Gray. Thank you. I am here on behalf of Delmarva. May I proceed?
Yes, please proceed.
Great, thank you. This is Dawn Kurtz-Crompton, again on behalf of Delmarva Power and Light Company. You have been presented today with Proposed Order 9864, which approves Delmarva's application to revise its transmission service charge for both standard offer service, fixed price service, and hourly price service. The proposed transmission service charge is based on the company's 2021 annual update to the Network Integrated Transmission Service Rate, as shown in the informational filing made with FERC on May 14, 2021. The application implements the procedure for establishing retail transmission rates as set forth in Order Number 6746, dated October 11, 2005, in TSC docket number 04-391. That settlement established a pass-through mechanism that permits Delmarva to establish transmission rates for retail customers that mirror the transmission rates that PJM charges to Delmarva under FERC requirements. The order in front of you today approves Delmarva's proposed rates for transmission service charges for SOS, fixed price, and hourly priced service offerings, effective with usage on and after September 1, 2021. As set forth in the staff memo, a typical residential customer using 845 kilowatt hours in a summer month should see an increase of approximately $4.05 or 3.65% to their monthly bill. Delmarva thanks staff for its preparation of the memo and proposed order and appreciates the opportunity to comment. Delmarva is in agreement with the order that has been presented to you today, and accordingly, we respectfully request that the Commission approve Order Number 9864. Thank you.
Thank you, Ms. Crompton. Is Mr. O'Brien representing staff on this matter?
Yes, I am here, Acting Chair, and thank you, Commissioners, and Acting Chair Gray. So Bill O'Brien on behalf of staff in this matter, and staff does agree with Ms. Crompton's summary of the case that she just provided. You do have staff's memorandum in front of you dated August 18th, 2021, in which staff describes the discovery that was conducted and the conclusions that staff reached, and ends with a recommendation to approve the transmission formula rate as proposed. So staff does support your entrance of proposed order number 9864. Thank you.
Thank you, Mr. O'Brien. And is Ms. Iori available to represent the DPA on this matter?
I am, Acting Chair Gray. Thank you very much. The DPA supports the proposed form of order and requests that the commission enter it. Thank you.
Thank you, Ms. Iori. Do any commissioners have questions or comments on this matter? Could I receive a motion regarding order number 9864, please?
Mr. Acting Chair, I move that we approve proposed order number 9864 and adopt it as presented. Thank you.
Thank you, Commissioner Drexler. Do I get a second?
I second the motion.
Thank you, Commissioner Correa. It's been moved and seconded to adopt order number 9864. Any discussion or questions? All right, all those in favor, Commissioner Correa?
Aye.
Commissioner Drexler? Commissioner Drexler? All right, Chair Winslow?
Aye.
I also vote aye. Is Commissioner Drexler available and unmuted?
Yes.
To
I vote,
vote
I'm sorry about that. I dropped off. I vote aye as well.
Very good, thank you. So it's been, order number 9864 has been unanimously adopted. Thank you. The next matter on the agenda is, in the matter of the application of Delmarva Power Light Company for an increase in electric base rates and other miscellaneous tariff changes, PSC docket number 200149. Is Mr. Geddes available for staff on this matter?
Yes, Mr. Acting Chair.
It's okay, it's okay.
Sorry about that, is Courtney Schultz, Pam Scott available for DPL on this matter?
Yes, Mr. Acting Chair, this is Courtney Schultz.
And Ms. Iori is available on this matter as well?
Yes, Acting Chair Gray. Thank you.
All right, Mr. Geddes, would you like to proceed?
Yes, Mr. Acting Chair, but before we do, Mr. Hartigan, I have some slides in connection with my re-argument. Could you possibly send those to the commissioners?
Yes, I will.
Could I ask that everybody get the slides, Jim?
Yes, well, I didn't want to send something to the commission without your, that's why I asked Mr. Hartigan to do that. I have also simultaneously sent the slides to the following people, to all of your counsel and to Ms. Iori. You should have them momentarily. Pam Scott, Clark Stalker, Dawn, Brian, yourself, Courtney, and Ms. Iori. I'm also asking them to be put up on the live stream if somebody wants to look at them there. Although I believe there might be a little bit of a hesitation with regard to that. So as soon as the four chairmen and the parties have these slides, I'd be happy to start.
I don't, this is just Ms. Schultz. I don't think there is a live stream, Jim, at least not one that I've been able to find with the meeting today.
Well, I asked whether it would be possible to put them up. I believe if you look at the live stream now, there's the empty chair. But I will tell you, in trying to use the live stream, there is a delay between the slides, i.e. if you say slide 1, slide 2, there's like a 5-second delay, which is a little irritating. So I think a better way perhaps is to just use the slides that I have forwarded to you. Acting Chair Gray, do you have a copy of these slides? First
I
slide's
have a
up on the live stream.
So I have a copy that have come by way of email, but it's somewhat voluminous. I mean, are we to absorb and digest this information on the fly in this way? If it's public information, was it feasible to receive it before the hearing?
Well, it's just as I was preparing my argument. First of all, it's 15 slides. It's not voluminous information, and I believe it will be very easy to follow. There are aids, and I was trying to visually help you, understand the argument, and I don't think it will be that difficult to follow. So I would ask your indulgence to let me start, and if it does become burdensome, I will try to make the requisite adjustments.
And for the record, this is Ms. Schultz. I mean, I'm just going to object to this. I mean, I think it's inappropriate to have this done on the fly, to not have given anybody an opportunity to see what's going to be presented in advance of this meeting, and also based on the fact that this was a, telephone argument. I just want to put my objection on the record.
Well, on August 4th, we used a similar format, and as always, these are, aids. They're not evidence, and I think they will assist the commission. And if the commission is free to look at them or not look at them, it's up to them. So I'd like to proceed if I could.
Just one moment, Mr. Geddes, please. Let me ask my fellow commissioners if each person has received this information and is in a position at this moment to follow the slide presentation through this discussion. Commissioner Correa?
Yes, I have received it and it is open and is working.
Commissioner Drexler?
I have not received it. I'm having trouble with my email. I'm going to try to correct this, but I have not yet received it. If it could be sent to my Gmail account, my alternate account, I'm having trouble with my State of Delaware account right now.
And Chair Winslow?
I received an email, but I have not, the slides were not downloaded, but now look like they're downloading. And now, yes, I do have the slides.
All right, Mr. Geddes, I'm going to allow you to proceed here under these circumstances, but as we get into this information, I'm still open and listening for the reactions to others who need to digest it in order to understand where we're headed. All right, so if you don't mind, you have privilege to proceed.
Thank you, Mr. Acting Chair. And Mr. Hartigan, could you send a copy of these slides to Commissioner Drexler's Gmail account?
Yes, I just did.
Thank you. Okay, thank you. I've gotten them. Thank you.
All right. With your permission, I will start. This motion is being brought for your consideration of what staff believes is a very important issue. Staff believes that it's a serious issue of the utilities' actions here, and will point out during the proceeding that Delmarva, I believe, maybe not intentionally, has deceived the commission staff, and most importantly, its customers. We believe that that Delmarva has compromised a prior commission order, that it clearly has violated the minimum filing requirements that require notification of any issue that is a departure from a prior commission decision and the revenue impact of that in their application. And having not disclosed those actions in its application, that it continued to make assertions in its rebuttal testimony and its post-hearing briefs, claiming that the modification was just a proposal to be considered by this commission, and that it had not implemented the change in the EDIT values that the commission ordered in its prior, in 9248 out of docket 170977. So let's be clear. What is this motion about? It is not about what staff knew or when it knew it. That's a false trail. And to use an old Alan Simpson analogy, a former senator from Wyoming who I had the privilege of meeting and trying a case in front of, you follow the rabbit, not the rabbit hole. What staff knew and when it knew it is not relevant, nor is the actual or estimated EDIT credits, or whether the settlement agreement could or should be modified. That is another rabbit hole that will be examined subsequently when Delmarva files its motion. Instead, what staff's motion is about is highlighting the actions the company chose to take or did not take related to the EDIT issue, and whether this commission is going to condone such actions. As we all know, there are two ways to do things, the right way and another way. Unfortunately, it's staff's opinion here that the company chose the second alternative. That's why staff has brought this issue to the commission's attention. We believe that this is like a shell game, and the company should be reprimanded for its actions. So, what do we know? Customers pay rates, and as a result of your order, which is slide 1, in 170977, the commission ordered that the estimated EDIT credits be flowed back to customers through a rate rider as a credit in rates to customers. The second slide shows that rider, and in effect what the numbers or the amounts were that the commission approved to be flowed back to the ratepayers. Now, Mr. Zeminski, in his testimony in front of the hearing examiner, stated, and this is slide 3, that the company's proposed EDIT balance would be flowed back to customers through a separate rider, which enables the parties to continue to have highlighted line of sight as to the amount of the EDIT benefits ultimately flowed back to customers. Line of sight. The next slide shows the balances that were on slide 2, I'm sorry, not the balances, but the rates for the EDIT credits. They're at the bottom of the page. They're semi-highlighted, but those figures correspond with the figures in slide 2 on the EDIT rider. Now, the next slide shows a markup of the tariffs that Delmarva submitted when it sought to include its interim rates, or sought to have the commission approve its interim rates, which were approved and went into effect on October 6th. You will see that there are changes to the distribution charges there in the middle of the page. You will also see the EDIT SIR credits, and it states there, refer to rider EDIT. From that, you can conclude that there were no changes at the time the company filed its interim rate request to those credits. And that's reflected on the following slide, slide 6, which shows a typical residential bill dated October 24th, which would be after the interim rates went into effect. And if you look at the bottom of the page, you will see the values for the per kWh are exactly the same as they were in the bill that preceded the interim rates. So as the company has stated numerous times, there has been no change in those credits. But what is really going on behind the scenes? The value of those credits, with the commission approved in its order, are not currently reflected in the interim rates. Instead, what the company did was to look at its cost of service, determine that because the actual taxes that they were paying were $1 million more than what the estimates were at the time the commission approved the settlement in 170977, that adjustment, which was reflected on their books, was not adjusted for the values of the commission's order. In other words, what the company did, it modified its cost of service, or it used its cost of service, its per book numbers that reflected a higher income tax than the estimates, and netted that against the EDIT credits. So customers are paying $1 million in rates, in base rates, higher than the actual values that the commission approved in 170977. So in essence, they have adjusted the commission's order without their knowledge, without their approval. And it's staff's position that that's inappropriate. That the staff, let me try it again, that the commission's order is a mandate. And by not making the necessary rate-making adjustment in its filing, the company directly disobeyed a commission directive. It also violated the minimum filing requirements because it did not identify this adjustment in anything that it filed with its application. It was only after minimum rates were in effect and that staff had raised this issue did the company, in rebuttal testimony in the latter part of October, highlight this as, quote, a proposal. Let me rephrase that, a proposal. So if you go down to slide 9, you will see a portion of the company's opening brief. Now, this was filed in March, months after the interim rates had gone into effect. The title of Section 13 says, Modification of EDIT Balances. The company's proposal to modify its EDIT balances to reflect actual tax credits received by Delmarva as reflected is reasonable. Again, it's proposal. And if you go over to slide 11, which is the concluding paragraphs of their treatment of the issue on their opening brief, to be clear, the company has not implemented this change at this point in time. Again, they have not implemented the change according to the brief. But that's not actually true, because the modification of the commission's order has already been effectuated, because the company did not make the appropriate rate-making adjustment to decrease their cost of service by the value of the credits that the commission had previously ordered. And that difference is $1 million. So there's no will be modified. It has been modified. It's been done. And they did it before they even addressed the issue in their application. So let's say hypothetically these credits are worth $10 a month, as set forth in the rate rider. Now they're only getting $9 a month because of this offset. The company using their book figures and not making the appropriate rate-making adjustment. But still, the bills say that ratepayers are getting $10 a month. Now, that's a hypothetical. But as we've shown on slide 8, the numbers have not changed for the credit. They're exactly the same. And so how does a customer, looking at its bill, realize that the values set forth on its bill are actually being compromised by $1 million? That the cost of service does not reflect those values, and therefore the base rates don't reflect those values, but have been increased by $1 million. The company agrees, and I'm on slide 13, it's not free to change its tariff without commission approval. Well, if they can't change it without commission approval, how can they change the effect of the tariff? And that's how they did it. They didn't come in and ask for a modification. They just changed or didn't change their book numbers to make the appropriate adjustment. And if staff had not found this, the commission would not have been aware of this. And everyone would have thought the values that are set forth on the customer's bills were the actual credits they were getting in rates, which is not true. Now, the question is, what are we going to do about this? The proper way to have reflected this is on slide 14. The company should have come in and filed to amend the EDIT rider. They do that on a monthly basis with the qualified fuel adjustment because it changes. And there's nothing to say because the estimates in the original docket 170977, since they, those credits may have been influenced by taxes, that the company couldn't come in and say, well, they have been changed. The settlement agreement should reflect that. And that was the argument on the 4th. But that's not the argument here. The argument here is that the company has not been transparent about this. They should have come in to modify the rider. They should have made the rate-making adjustment to reflect the value of the credits, but they didn't do it. And if you look at slide 15, 2.1.5 of the minimum filing requirements, that's exactly what they should have done in their application. It requires that if a significant element, I would include $1 million as significant, of an application, which to the applicant's knowledge represents a departure from prior commission decisions and associated revenue requirement, this needs to be highlighted in the application. So it's staff's position that the commission should not condone this type of behavior by allowing the company to use lower EDIT values than those approved in a prior commission order. They will claim in their argument that somehow this is staff's fault and that staff should have known and staff should have done this or that, and especially in the 2 hours on August 5th before the minute order was put in front of you. But as I said in the beginning, this is not about staff. We are not the regulated utility. The company is the regulated utility. They have regulations and rules that apply to them. That's what the issue is, and the fact how this was treated. So it's staff's position that this should not be allowed to stand. Did the company lower the EDIT amounts below what the commission ordered to be used in order number 9248? Yes, it did. Has that unauthorized change impacted customers? Yes, it has. Did the company disclose this modification to the commission in its filing? No, it did not. So we asked the commission to not condone this type of behavior. It makes a mockery of the minimum filing requirements and the requirement that utilities be transparent. What is the reward for this? We do not think that the reward should be, after these statements that I believe one could argue are misleading, that the bills aren't structured in accordance with the commission's prior order, and that they, in their brief, suggest that there has been no change when there has been. That staff asked that the refund be increased by $996,000, and the issue of whether the EDIT credits can be modified await a proper filing by the company requesting such a modification. Thank you.
Thank you, Mr. Geddes. So I'm showing that Courtney Schultz, Pam Scott, representing DTL in this matter. Are they available and ready to present their argument?
Yes, Acting Chair Gray, this is Courtney Schultz. I'm ready to proceed.
Thank you. Please do.
So first, I need to start off by saying that the company is incredibly disappointed that we're all here today, again, talking about this issue when the Commission charted a path forward at the argument on August 4th. The company was in the midst of preparing the motion, directed by the Commission to retee the EDIT issue for the Commission's consideration when staff filed this instant motion. And before I get into the meat of the company's opposition, I really must take a moment to say that the company takes offense at any suggestion by staff that it did anything that was misleading, obstructive, evasive, or, as Mr. Geddes mentioned today, deceptive with respect to this issue. The company's reputation is important to it, and I really think that this constant stone throwing by Mr. Geddes to the company is unnecessary, unprofessional, and unwarranted on the facts of the case. I don't think any admonishment should be had here, and it should never have been suggested. Now, I can't keep track of all the new arguments that staff has tried to put forth on this issue since it was addressed before the Commission on August 4th. First, in the motion to re-argue, it was that staff was unaware that the EDIT balances reflecting actuals were in the interim rates revenue requirement. That's what was presented in the re-argument motion, and that's what we addressed with all of the facts in our response. Today, I'm hearing a slightly different argument, and that is that Mr. Geddes says that the new argument is noncompliance with the MFRs, and that the company hasn't been transparent. I think we spent a lot of time on transparency during August 4th when we talked about this issue. And indeed, you may recall Chair Winslow emphatically said not once but twice that he had heard the facts and he didn't think that the company had any nefarious intent. That is, in fact, true. The company had no nefarious intent here. And I think to the extent that Mr. Geddes is raising some argument about what should or shouldn't have been in the application, in compliance with the MFRs, I mean, that ship has sailed as well. I mean, this is an argument that could have been raised with rebuttal testimony at the evidentiary hearing and post-hearing briefing at the argument on exceptions, and to wait to file some motion to re-argue, not include it in that motion, and now simply include it today, it's improper. But let me go back to the beginning. There's two problems with staff's motion. First, staff has failed to meet the legal requirements necessary to sustain a motion to re-argue. And second, the facts don't support the motion as laid out in our response, and which I'll slightly touch upon today, even if those facts were omitted from staff's motion. So let's look at the legal standard, which is what you should be first and foremost concerned with when you consider how to rule on the motion. Interestingly, staff didn't mention the standard upon which its motion must be reviewed, and it didn't cite a single case in support of its right to the requested relief today. And so under Delaware regulation in the Administrative Code, Section 1001-2.22.2, staff's motion doesn't meet that standard. That standard requires that a motion for re-argument present grounds that are different from the arguments previously made to the Commission, and that the movement show the Commission that it overlooked controlling principles or misapplied the law or facts in a way that would change the outcome of the underlying decision. Now, what was the underlying decision? The underlying decision was a tie vote on whether or not to accept the company's proposal to substitute actual balances with estimates, and a subsequent vote to sever the issue and direction that the company file a motion so that the Commission could finally determine this last issue in the rate case. Now, staff hasn't mentioned in its motion papers, and it didn't mention today, what controlling principles have been overlooked by the Commission or how the Commission misapplied the law or the facts. All of the facts were at staff's disposal at the time of the evidentiary hearing, at the time of the argument on August 4th. And the fact that staff chose not to raise this issue to the commission or to the hearing examiner then, as it now does, doesn't provide the basis for an appropriate motion to re-argue. As a reminder, the commission considered the controlling principles and the law as applied to the facts in this case, even receiving advice from its counsel during deliberations on August 4th on this matter, and ultimately the commission concluded the issue should be severed. And in true, I don't know, I guess I'm looking for the right word here, and I guess it's not really coming to me. But ultimately, we need to stick to what the legal standard is, and staff has not met that standard with this motion. There is no concern or worry by the commission that this issue will not be fully fleshed out, as the company will prepare the motion as it was directed to do, and the commission can consider the motion on all facts. You may have recalled that you heard some new testimony on August 4th, which may have influenced or may not your preference for further development of the record on this issue. And that was that Delmarva was the first utility to start giving this money back. And so it was trying to simply correct course and provide only the actual true amount of savings to customers that it received, nothing more, nothing less. So respectfully, I think we now need to turn to the second issue, which is what are the facts here and what is it that matters? Mr. Geddes, despite what he wrote in his motion, now claims that what staff knew when has nothing to do with his motion. Respectfully, I think the reason that that argument has changed is because the company has now put all of the facts in front of the commission, which reveal that staff did know all along how the company had treated this issue once the parties had it out in the open, right? So once the parties had it on the table that the company's application included the proposal to change the EDIT balances, they had a lot of discussions about that. There was discovery about that. There were communications between staff witness Paff and company witness Zeminski. And company witness Zeminski didn't hide anything from company witness Paff. You saw in my papers, there's an email from Mr. Zeminski where he tells Mr. Paff in no uncertain terms, the actual EDIT dollars are what is used in the cost of service per books. There's no separate adjustment. And so I think we do need to keep that in mind. So yes, the company's request wasn't in an adjustment. And look, the company acknowledged in hindsight, given all the confusion and consternation around this issue, it could have and perhaps should have done that. But as we all know, the saying goes, hindsight is 20/20. So to the point, Mr. Paff and staff knew as of August 21st, 2020, before interim rates went into effect, that there was no separate adjustment and the actual EDIT balances were in the company's revenue requirement. And what did he do? He proposed his own adjustment in his direct testimony to remove those balances from the revenue requirement. This happened with any number of other issues that were in play. And so what happened after that? Interim rates went into effect on October 6th. On the company's motion, I'm sorry, somebody's juggling a lot in the background. Could you just go on mute if you are not? Thank you. So interim rates went into effect on October 6th. The company made a motion, which was decided by the commission on September 9th. At this point, everybody knew the actual balances were in the revenue requirement because that was part of the company's request in this case, just as the dollars from any number of other adjustments that had yet to be determined by the commission were in the revenue requirement. That happened without objection from staff. At the hearing and in briefing, the company believed it had clearly articulated the impact of its proposal on customers. The company was focused on the EDIT credit the customers are receiving as a result of the determination in the docket 170977 settlement agreement, and whether those amounts were the same. And apparently staff was concerned about whether the overall base distribution rates were higher as a result of the company's inclusion of the actual EDIT balances. But that doesn't make what the company said inaccurate, untrue, or misleading. It simply means that throughout this case, the parties have continued to just look at this differently. And that's not That's not anything that is anybody's fault, but it also doesn't mean that the company tried to intentionally deceive or intentionally mislead anyone. So, of course, base rates are higher. Interim rates are set based on the company's fully litigated requested revenue requirement. It includes its request to use actuals on this issue. It includes its request on other issues. To Mr. Geddes' point that he made in his argument today, it included a 10.3% ROE. The settlement agreement in the commission order of 190977 included a 9.7% ROE. But we're not here today arguing that the company wasn't allowed to change that term of the order in this base rate case, because that's simply not the way things work. So what's never changed is that customers are receiving today what they've been receiving since 2018 in terms of the rate used to determine how much of the EDIT balance they get each month in the form of the credit, which is based on their volumetric use. As shown on the customer bills that we attached to our response, and actually that Mr. Geddes showed you today, and in the EDIT rider itself, those rates have not changed. End of story. They might change if the commission ultimately approves the company's proposed request for the EDIT balances. And I apologize, hold on one second, I'm going to switch my mode of hearing here. My earpods have died, so apologies for that. Hopefully everyone can still hear me. So when the commission decided to defer resolution of this single issue to be considered on motion made by Delmarva, the company's position was that the dollars included in the revenue requirement reflecting its litigated position should properly remain in the revenue requirement until such time as the commission ultimately decided the issue. This is what happens as a matter of course in every single case where interim rates are in effect. When the issues are decided, the revenue requirement is adjusted to mirror the commission's decision. This issue has not yet been finally determined, and so it should remain in the revenue requirement. And immediately after the hearing, the company made clear to staff that this was its intention, and that if staff disagreed, we would have to deal with that before the commission. And quite honestly, commissioners, it was my intention that we would deal with this issue on the 5th, had staff not agreed to include these amounts in the revenue requirement. But staff didn't disagree. Staff agreed with the revenue requirement that was developed in consultation with its witness, with DPA's witness. And so, in conclusion, you know, all I'm saying here, and as you saw in our response, Delmarva's counsel discussed this with Mr. Geddes and tried to ensure transparency on this issue in the minute order. Delmarva's representative spent hours physically in the room with Mr. Paff and Dover for at least 3 hours on August 5th. The dollars associated with the EDIT balances issue were central to those discussions, and Mr. Paff indicated he was discussing the matter with Mr. Geddes, who chose not to remain in Dover that day. The revenue requirement in the minute order was fully vetted by staff, DPA, and the company before it was submitted by staff to the commission for review and approval in the minute order. And so I guess the last thing I would like to tell you today is that I want to make sure that you're all aware of the ramifications of your actions on the motion today. The regulations clearly provide that when a timely motion to re-argue is filed, the commission shall suspend the finality of the order that's the subject of the petition. So when Mr. Geddes filed his motion, the minute order was suspended, which means that the company will be prevented from implementing rates on September 1st of 2021 that are based on the overall revenue requirement in that order, which reflects your determinations in the company's case on August 4th. This means that until such time as this motion is resolved, customers continue to pay rates that are higher than those based on the appropriate overall revenue requirement. They're subject to refund. That refund will be delayed. Now, if you grant the motion, then we have to schedule another argument on this issue. And I suspect the same process concerns will emerge, and we may find ourselves in the same place we were on August 4th, with a vote to sever and consider the company's request on further motion. So today is not intended to be a re-argument of this issue. Now, if you deny the motion, which I think you should, the company will file the revised tariffs designed to collect the revenue requirement in the minute order today, as contained in the minute order schedule, and we can deal with this matter on the full facts, which is what the commission ordered when Delmarva files its motion on September 3rd. Now, thank you for your time, and Delmarva respectfully requests that staff's motion be denied and that Commission enter Delmarva's proposed order allowing for the implementation of rates in the minute order to occur with refund to customers on September 1st. Thank you very much.
Mr. Acting Chair, sorry, go ahead. I apologize.
No, please, go ahead. Who's speaking?
A short rejoinder, please, with your permission. It's our motion.
Mr. Gaddis, okay.
Yes,
yeah,
I'm
go
sorry, I
ahead.
didn't identify myself. May
Go
I
ahead.
proceed?
Yes.
I'll be short and hopefully to the point. As I suggested in my opening, the company has conflated the issue about process with Commissioner Gray, or Acting Chairman Gray, pointed out on August 4th, with substance. We are not asking today to have this issue decided substantively. That should be done with a motion by the company to modify its tariffs. What we are bringing for you is the understanding now of what actually the company was proposing and what impact it had on customers. Now, it's clear that I don't think there's a statute of limitations on the NFRs, and you could argue that the MFRs are a reason why we're bringing this, partially. And the hearing before you last on the 4th was not an evidentiary hearing. It was a hearing on that exam, on the hearing examiner's report. You didn't take evidence. That's not the purpose of that. So, as the company continues to say, the staff should have known. But as I showed in slides 9, 10, and 11, that's not what the company said. That's in March. Modification of EDIT balances. They say it's clear the company has not implemented this change at this point in time. Well, clearly that's not true, because council just told you that they had implemented at the time of the interim, when the interim rates were placed in effect. I can tell you for a fact that on the 4th, at the close of the hearing and when this was supposed to be severed, I was not sure whether these values were the ones that were in the commission's order or not. And for them to say that somehow we acquiesced to this in trying to get a minute order in front of you is, I do believe, a little disingenuous. After 300 days and 7,000 hours, my responsibility as your staff rate counsel was to get a minute order in front of you so that you could sign it and the refunds could be given as quickly as possible. To suggest that somehow I did know is not true. Ms. Scott didn't call me just once. Ms. Scott called me twice because she had not, in the first telephone call, indicated that the actual balances were in the interim rates. She had to call me back a second time, and she will, as she's an honest person. My first response was, that's a problem. Now, when I learned about this approximately 9:30, before 10 o'clock, you recall that we were adjourned until 10 o'clock. We did not have a minute order. I had sent it over the night before, but we didn't have figures. It was adjourned. There was an 11 o'clock call. No order. We were back and forth on this particular issue, and it became clear at 11:56 on an email that's attached to my motion, Exhibit A, that the company wanted language that clearly stated that the interim rates had actual balances. Now, 9 through 11, those slides, opening, hearing brief, not one word about actual. But in their motion and response, or their response to my motion, they used it 58 times and 38 times in just their pleading itself, 22 pages. So there seems to be some change in terms of what the company suggested staff knew and what staff really knew. it's a little hard to get around the fact that in a post-trial briefing, they said that this proposal was just a proposal. And look at the issue proposal. A proposal is something that we are thinking about doing, not something that's already been implemented, i.e. using the actual balances, ADIT balances, rather than the ones that were approved by the commission. So I want to make clear, this is not about the issue of the agreement itself and whether it should be modified. This is about how the company directed itself during this case. And that was not clear in the beginning. It was not even proposed by the company, but it became very clear after the difficulty in trying to get something that you could sign virtually, i.e. the commission did not meet in person on the 5th, that this was an issue that was going to have to be resolved at a subsequent time. And therefore, we filed as soon as we could to indicate to the commission that we believe that how this had been treated and how the company had disclosed this was something that the commission should not condone. The resolution of this particular motion will not resolve, contrary to what counsel said, resolve the issue of whether this commission wants to allow the company to, in essence, change the terms of a settlement agreement that it approved. That's a substantive issue. That's not what's before you today. Today is a process issue and how the company dealt with this issue, and we don't think they did it correctly. Thank you.
Thank you, Mr. Geddes. So let me just interrupt here. Let me just interrupt here for a second. I want to pause here a minute and determine, does the DPA have an interest in this matter or a statement to the commission? Ms. Iori still tied into the hearing?
I am Acting Chairman Gray. I am awaiting direction from my client.
Right. Is that going to take a measure of time? Should I move on, or are you momentarily sitting with a decision?
I probably will have that momentarily.
All right.
We have been communicating.
All right.
Okay.
So
I have just received my communication and my instructions. Although we were not a joint movement with staff on the motion, we are sympathetic to much of what staff has argued in this in its motion, and so we support staff's motion and would request the commission to grant it. Thank you.
Thank you, Ms. Iori. I think I heard Ms. Courtney Schultz trying to make a statement or had a rebuttal.
If I may.
For Mr. Geddes? Yes, please.
Yes, if I may, very briefly.
Yeah, but this is staff's motion.
I understand.
And normally, well then, will you permit me to have a comment to your comment, if the chair will?
Sure. Go ahead.
Okay.
I will allow it briefly. So let's agree that we've heard the essence and foundation of each argument. So at this point, can we address or make comments about the rebuttal to the arguments made by the other parties? So Ms. Courtney Schultz, please.
Thank you, Acting Chair. Briefly, to address Mr. Geddes' rebuttal, I think, again, what that evidence is exactly what has gone on here. Staff looks at this issue one way, the company looks at it another way, but whether or not we concern ourselves with who knew what when, which I do think is important, the company's efforts at transparency, I think, are clear, especially on the 4th, especially on the 5th. For Mr. Geddes to continue to suggest in his rebuttal that the company somehow improperly put these actual balances into interim rates ignores that all litigated positions are implemented with interim rates. There's no reason why, if staff had a concern over how this was addressed in the application or a concern over the MSRs being not strictly adhered to, that this couldn't have been raised earlier, before today. And I would agree with staff that the commission is not here to address this on the merits, which I talked about earlier. But if the commission grants this order, then we will be back before you on another argument, and it will not have new facts, it will not have new evidence, it will not have all the information that you wanted to see to satisfy your process concerns, Commissioner Gray and Commissioner Drexler. And so I fear we'll be back where we started. So the information that's been put before you today, to my mind, is not new. Staff has made its arguments about how it would have liked to see this raised by the company and how it didn't appreciate the way that it was raised. And so I think what I will leave you with is that, and just another note, which is that if the decision today is anything other than a denial of this motion and essentially reinstatement or lift of the suspension on the minute order, then the company will need more time, obviously, to figure out what the tariffs need to look like. But if this order is denied, the company can proceed to file the tariffs. The new rate can go into effect. And if we determine when the EDIT motion is filed that the company's actual balances are not the appropriate balances to be used, then whatever portion was recovered in rates of the EDIT actuals between September 1st and whenever that motion is decided, it'll be refunded. If the actuals are determined, then the rates are good. They won't need to change, except the EDIT rider will presumably change to reflect appropriate amortizations, and that's all very complex and complicated. But thank you very much for the brief time to respond.
Thank you, Ms. Schultz. And so, Mr. Geddes, you'll have the last word, and then I'll open this up for comments from commissioners. Mr. Geddes.
Yes, to be brief, I think the commissioners should ask themselves, are the customers receiving the same benefits from EDIT that they were prior to the interim rates being implemented? And if they're not, on what basis did the company modify the values that the commission had set forth in its prior order 170977? I am not aware in my history where a company has gone ahead and modified an order by the commission without coming to the commission first and asking. There is no place on these bills that show what is actually going on with regard to the value of these balances. And as Ms. Schultz said in closing, that they are using the actual balances. And they're seeking approval of what they've already done, which is, in a Latin phrase that lawyers are familiar, nunc pro tunc, as if in the beginning they've already done it. They didn't ask permission. The rules and regulations require them to ask permission before they implement something like this in violation of a clear commission mandate. Thank you.
Thank you, Mr. Geddes.
Acting Chairman Gray, may I? This is Gina Iore for the DPA.
Yes, Ms. Iore, please.
I guess I just have a question more than an actual response, but it's in response to something that Ms. Schultz said during her most recent rebuttal. And she said something about how the commission won't have all the evidence that it apparently wants for the motion that I guess is coming at some point in time on the actual settlement agreement. And I guess my question is, there's been no evidentiary hearing on it. I thought I guess I would like to have an idea going into this as to what we are going to be arguing in that motion.
Acting Chair, did you want me to
Ms.
take a crack at that?
Just let me clarify, Ms. Iori, A, to whom is the question directed? And second, which order are you addressing, or are you addressing the settlement agreement? I'm not clear in your question. Can you rephrase it?
Well, what the commission did at the oral argument and deliberations, it split 2-2 and directed Delmarva to file a motion with respect to amendment of the settlement agreement, because that's what this all comes down to. That's the genesis of this dispute in the first place.
Yeah,
And
agreed.
what I thought I heard, and maybe I misheard, but what I thought I heard Ms. Schultz say was that there would be additional evidence that the commission would be considering in that motion. And since there hasn't been an evidentiary hearing, I guess and I don't know who I'm directing this to. I mean, I think I'm directing it to the commission as to what the commission expects from us. There will not have been an evidentiary hearing, so I'm not sure what evidence we would be submitting. I thought it was a legal argument.
It is.
So
Definitely is. This is Jim Geddes, and it depends on what the commission wants to do, whether they want to sign staff's order or they want some other resolution. But I don't think it involves facts.
Yeah. My perception, Ms. Iori, and I could be wrong, as I recall our last meeting, is can we change the settlement agreement? Is it amenable to being changed? And if yes, what, if any, are the consequences? And I'd also agree with Mr. Geddes. It sounds to me more like a legal discussion. And when I've heard comments that some of these matters that are before us today could be rolled into that discussion, into that forum, I'm a little confused about how we get the scope of the question around the settlement agreement to handle these issues that are more rate-making related that we're having in our discussions today. So I'll leave that on the table.
Sorry.
Yes, please, Mr. Geddes.
Just point of clarification, the essence of staff's motion is that the refund be increased by $1 million to reflect the actual values. And that can be done, or the commission can decide not to do that. But that's what staff is requesting, that while this is pending for however long, that the refund to the customers include the additional $1 million, which they don't include at the moment.
But
that's the essence of it.
Respectfully, that's not in staff's motion. It's not a part of the motion, and it's an improper request for this motion. This is a motion to re-argue. Jim, let me finish. This is a motion to re-argue an issue. So if the commission is going to make a decision other than the decision it already made, which is Delmarva, please file a motion to address the EDIT issue, then that is another matter. And until such time as we have that re-argument, if your motion is granted, then the revenue requirement that is in play is the interim rates revenue requirement. That will reflect
the first paragraph only asks that the independency of this, that the $1 million be placed back in customers' favor. That's all we're asking.
Excuse me, Mr. Geddes, just a moment. I'd like the floor, please.
Sorry.
Did I hear Chair Winslow request?
Yes, I'd like to ask Mr. O'Brien, who is attorney for the commission on this issue, a question.
Please.
Mr. O'Brien, are you there?
Yes, I am, Chair Winslow, or Acting Commissioner Winslow. I am here.
Mr. O'Brien.
Wait. point of clarification, it's commissioner, not acting commissioner. Thank you.
Mr. O'Brien, with respect to the $1 million issue, we can resolve that despite the motion. Is that correct or not? In other words, if we dismiss the motion, I guess, will at the end of the day, will the consumers get what they're entitled to with respect to the EDIT?
My understanding, Chair Winslow, is that yes, they will. Right, that $1 million will be decided after Delmarva files their motion to modify the settlement agreement. But the entire amount that was collected in interim rates, based on their proposed increase, is subject to refund. Now, the parties did come up with a minute order that set rates based on the issues that were decided, leaving out this one issue. Now, that minute order, the revenue requirement in that includes Delmarva's position on this disputed issue. But to answer your question, Delmarva has stated several different times that even under the rates that they're going to put into effect with the minute order, they will refund all the way back to when the interim rate was put into effect, the monies collected under their proposed solution to this dispute in order to make the customers whole based on the numbers from the settlement agreement. So hopefully that does answer your question, that as far as the impact to the customers go, certainly there's been an impact based on what they've been paying all along, but that impact will be reversed in full with interest later if staff prevails on this disputed $1 million.
Also, with respect to the process issue, which I think is probably important, are there other stakeholders and other utilities that might be interested in chiming in with respect to the issues in this matter?
Well, if you're talking about the issue that's coming down the pike, I would say that the parties might be in a better position to answer that, or at least staff would, or DPA, but I don't think so. I think that this, Delmarva had a separate proceeding on the TCJA regarding the change in the corporate tax. So that was all taken care of as part of their rate proceeding and resulted in the settlement agreement, which is in dispute right now. So I doubt if other utilities would have that same issue.
Okay, thank you.
Thank you, Chair Winslow and Mr. O'Brien. Any other commissioners have comments or questions on this issue?
This is Commissioner Drexler. I have a question for Mr. O'Brien.
Yes, please.
Mr. O'Brien, assuming this EDIT issue has been severed, and it was from the rate case, how does approval of the staff order today affect the implementation of the terms of the minute order September 1st?
My reading of the order that staff presented with its motion is that the minute order, the revenue requirement from the minute order, would be lowered by the amount of this dispute. And in essence, the default position would be in favor of staff. That would, well, I won't go into the ramifications of that, but yes, staff did ask in its proposed order that that minute order be adjusted to go in its favor on this issue rather than in Delmarva's favor on this issue.
Thank you.
All right, so if there are no other questions from commissioners on this issue, I guess I would ask for a motion with regard to the proposed order number 9863.
I'm sorry, Acting Chair Gray, this is Ms. Schultz.
Yes?
Just one quick point of clarification. I believe both orders submitted by staff and by the company are both given the same number. So I think the proper inquiry would be whether it would be to approve Delmarva's proposed order or staff's proposed order, just for clarity, since they both have the same proposed number.
Okay. All right, so with that clarification, do I have a motion to approve either order that's pending in front of the commission today?
I move that the commission approve Delmarva's order.
Is there a second among commissioners? I don't hear a second on that motion, Mr. Chair. Is there a motion to approve staff's order 9863?
Yes, so moved.
I second the motion.
It's been moved and seconded to approve staff's motion number 9863. Any further discussions amongst the commissioners or questions?
This is Ms. Schultz. I do have a question. I do not have.
I'm sorry, Ms. Schultz, they're deliberating.
Sorry,
He asked,
sorry.
I thought he was asking for questions from the floor. Sorry.
No, this is questions among the commissioners. Sorry. Any questions or comments among the commissioners with respect to the motion?
Yes, I don't believe that staff has met its burden with respect to the motion for re-argument. That's what's a primary reason for my position. Bye-bye.
Okay. And I'll make a couple of comments. I'm a little bit concerned in the discussions and presentations that I've seen that the bills didn't change when don't appear to change when the refund amounts did. And in large measure, some of the comments that were made about proposals versus implementation that had already taken place are concerning me. So I plan to agree with staff's motion in this regard. So we're at a point where we should take our vote, and I will ask Commissioner Correa, how do you vote on this?
Aye.
Commissioner Drexler?
Aye.
Chair Winslow?
No.
And I'll vote aye in support as well of staff's motion here. Okay, so thank you very much, everyone, for your presentation and your discussions on this matter. The next item on the agenda is the matter of the application of A1 Restoration, doing business as A1 Energy for an electric supplier certification within the state of Delaware. It looks
Excuse
like
me.
Yes?
I'm sorry, Acting Chair. I do have a very important question for implementation purposes of the order that just got approved.
Wait, whoa. Mr. Chair, you've moved on to another issue. If I know what I think I understand that, the motion based on the discussion, that the order is approved, but there may be, through the agreement of parties, some further, well, we can't do that. You've approved the order. Okay, never mind.
I'm simply seeking, Commissioners, the opportunity to ask a question about the order that was just signed off on. The order has no dates in terms of compliance. The company has a lot of work to get tariff leaves prepared. It cannot simply file tariff leaves today on the new revenue requirement that the Commission has just approved with passage of this order. And so this order does not have a timeline for new rates or the implementation of the new revenue requirement. The prior order is suspended. And so I'm just trying to ensure that Delmarva can, ensure full compliance with the directive today.
Okay, so
why didn't you make those comments to us before during your argument?
Well, I did. I indicated that Delmarva was prepared to file its tariff lease today if the order was denied, but that if it was granted, then Delmarva would need additional time. And Mr. Geddes' order doesn't provide any of that.
How much time do you need?
Yeah. Mr. Chair, that's exactly the question I was trying to get on the table, and I would appreciate as well an estimate from the company side, because it's clear for me that this isn't going to be a very straightforward, immediate turnaround by tomorrow, but I would have to defer to the company because I think you, the company, would understand the scope of what now needs to be done.
And if you'll bear with me one moment, I know I have that information. And for purposes of clarification, I assume all of the commissioners are aware that the order that was just passed included a reprimand that Delmarva argued strenuously against. But let me look for that. I think at a minimum, we need until September 10th to get the tariff lease in order.
Would it be reasonable, Mr. Hartigan, would it be reasonable to request that this commission get an update on status in our next meeting scheduled in September?
Yes, we can do that.
Because
Ms. Schultz, does that in any way provide any comfort level that you can use that opportunity to keep the commission informed and surface any issues that are unknown to you today as a consequence?
I think that that's fine. I guess the only other question I have is, I don't know that I see anything in the new order that's asking Delmarva to file the motion on the EDIT issue. Because again, this order just superseded the minute order, which is no longer in effect. So, do we want to wait to take care of the EDIT issue till after the September? We were originally going to file it on the 3rd, but I'm trying to work through these issues.
Acting Chair, this is Bill O'Brien. May I speak?
Yes, please. Yes, you may.
Okay, and the parties can correct me if I'm wrong, but the suspension of the earlier order was only during the pendency of the motion for re-argument. The motion for re-argument has now been granted, and the relief from the motion was also granted. So I don't think that suspension is in place anymore. This order simply changes the revenue requirement from that minute order to remove the disputed amounts. So that minute order is no longer suspended now that you've granted the motion.
So, Mr. O'Brien, is it your position that with this order that was just entered, we're now going to have re-arguments on the EDIT issue, since that's what was sought?
No.
Are we now doing the motion?
No. They not only did they grant the motion for re-argument, they heard the argument on its merits today and made a decision. That is now over. So the minute order is back in effect, other than the number that needs to be changed based on the remedy from this motion for re-argument.
When you say heard on the merits, you're not talking about the EDIT issue. You're talking about the motion to re-argue, right? You're not saying the EDIT issue has been resolved.
Of course not. Of course not.
Okay.
It's a motion for re-argument, which suspended the earlier order while it was pending.
Right. I guess my problem is I feel like the order granted a relief that was other than what was requested. So the request in the motion was for re-argument. The order just changed the revenue requirement. And I'm happy that I'm getting additional time to do the tariff lease because I could not implement by September 1st or get the lease filed today on a new revenue requirement. But in terms of the motion, I think what I'm hearing you say is despite the fact that the commission granted the motion for re-argument, there will be no re-argument on this issue. Rather, the motion will proceed. Am I
All right,
correct?
no, that is not correct.
That is not correct.
The motion for re-argument was granted. The re-argument was made, and now it is over. Now, we still have the motion regarding the settlement agreement, of course.
That's correct, as I see it, the substance of the settlement agreement and how it should be modified. But in the interim, the refund will include the additional $1 million.
All right, I'd like to move along the agenda. I would invite that staff and council might be able to confer around these matters, and I think that Matt Hardigan has indicated he will offer some time as a status update in our upcoming September meeting. So thank you again, everyone, for what is clearly a passionate issue, but we will move forward from this point on the agenda. In the matter of the application of A1 at Restoration, doing business as A1 Energy for an electric supplier certification within the state of Delaware. And I have Mr. Tom Walsh, who is presenting on behalf of staff. Mr. Walsh, are you there?
Yes, Acting Chairman Gray. This was taken off the consent agenda simply because there was, in the proposed order 9869, staff had included a recommendation to approve issuing the electric supplier certificate, but to also require within 10 business days of approval, the company to provide a $10,000 bond. This was not typical, and that is why we put it on the regular agenda for clarity. It was circulated to all the parties. A1 Restoration had a copy, of course, and so we simply thought that it was the better avenue to put this on the regular agenda than the consent agenda, so that the commission was aware and that this could be put on the record that we are requiring $10,000 bond based on A1's lack of experience as an electricity broker, and that they obtain that bond from a company approved by the Delaware Department of Insurance. And I included in the footnote the Department of Insurance's website listing all those approved companies for bond issuance. With that, I do not believe there's any disagreement as to Order 9869, and staff respectfully request that the commission approve.
Thank you very much, Mr. Walsh. Is there anyone present who's speaking for A1 Energy? Are you on mute, or are you? Okay.
This is Mike Perica with A1 Energy. President and
Good afternoon. Good afternoon, Mike. Can you, does the court reporter need your name and your affiliation?
I have it, Commissioner Gray.
All right, very good. So, Mike, what is your relationship to A1, and what are you offering or presenting to the commission today, please?
My relation with A1 is I'm going to be the Director of Procurement, and I'm just asking Acting Chair Gray and Commissioners, we respectfully request that you approve A1 Restoration's DBA A1 Energy's request for certification to broker electric supply services in the state of Delaware. And as was noted, we are prepared and have the approval of the $10,000 bond through Great Midwest Insurance Company, which is one of the noted companies on the provided list provided on the website. So we have all of that information, and we are prepared to move forward upon acceptance of us and granting us the ability to hold these services. Thank you.
Thank you, Mr. Perica. I appreciate that. Ms. Iori, is there any offering on this issue from the DPA?
No, Acting Chairman Gray, thank you.
All right, commissioners have any questions, concerns? Could I receive a motion to adopt order number 9869, please?
So moved.
I move that we adopt the order number 9869.
And I
Okay, I think I heard Commissioner Drexler move. Commissioner Correa, will you second?
Yes, I will second it, yes.
Okay, thank you very much. It's been moved and seconded to adopt order number 9869. Any questions, comments from commissioners? Hearing none. Commissioner Correa, how do you vote?
Aye.
Commissioner Drexler?
Aye.
Commissioner Winslow? Commissioner Winslow, are you still with us? Okay, I don't hear a response. So Commissioner Gray also votes yes, aye. And so the matter has passed. Order 9869 is adopted. Thank you. And the next item on our agenda in the hearing schedule is in the matter request for approval of Delmarva Power and Lights Company's 2021 Energy Efficiency Surcharge Rider Rate. And I believe Dawn Kurtz Crompton, are you available to speak on this matter for DPL?
Yes, thank you, Acting Chair Gray, and good afternoon to you and the commissioners. This is again Dawn Kurtz Crompton on behalf of Delmarva Power and Light Company. This hearing does pertain to Delmarva's Energy Efficiency Surcharge Rider Rate in connection with docket 20-0739. Before I continue, I just want to make sure that company witness Brian Talley is on the line and is able to hear me. Brian, are you there?
Yes, this is Brian Talley with Delmarva Power.
Great, thank you. We can hear you. So if it pleases the commission, I would like to give a brief procedural background on this matter and then present Mr. Talley for some testimony. Pursuant to the requirements of order number 9453 in docket 170985, on October 29, 2020, Delmarva filed an application for approval of the 2021 Energy Efficiency Surcharge Rider Rate, which I will refer to as the EE Rider Rate. Delmarva's filing pertained to the EE Rider Rate for year 2 of the commission-approved Energy Efficiency Program, and the application included clean and red line versions of the revised electric tariff leaf number 127, as well as detailed rate design calculations and work papers for the development of the EE Rider Rate. As will be discussed in greater detail during my presentation of company witness Brian Talley, the proposed Energy Efficiency Surcharge Rider Rate of 0.000828 per kilowatt hour for the following service classifications: classification RSH, classification R-TOU-ND, and classification PIV. The application was assigned docket number 20-0739, and on November 24, 2020, the Delaware Division of the Public Advocate filed its statutory notice of intervention. On December 2, 2020, the Commission issued Opening Order 9694, which allowed the proposed rate to be implemented, subject to refund, effective with usage on and after January 1, 2021. On December 9, 2020, Delmarva submitted a compliance filing pursuant to Order 9694, which enclosed the tariff sheet revisions necessary to implement the EE Rider rates on the service classifications on leaf number 127 that I mentioned earlier. Order number 9694 also required that Delmarva published public notice for proposed EE Rider rate on or before December 18, 2020. Delmarva complied, and the affidavits of publication for the News Journal, Delaware State News were docketed on December 28, 2020. No public comments were submitted during the public comment period, and Delmarva's proposed interim rates went into effect on January 1, 2021. In the subsequent months, Delmarva met with staff to respond to staff's questions and to provide additional detail in support of its work papers and calculations for the year 2 EE rider rate. In August of 2021, Delmarva published public notice for this evidentiary hearing. On August 13, 2021, Delmarva docketed the affidavits of publication for the 3 aforementioned newspapers with respect to this hearing today. Delmarva would like to thank staff and DPA for their efforts in this docket and thank staff for preparing its memo and proposed order 9866. I would like to briefly address some housekeeping with respect to the exhibit log, which staff has prepared and is linked on the agenda that's been presented to the Commission today. The exhibit log has 8 exhibits as agreed upon by the parties as follows. Exhibit 1 is Delmarva's application. Exhibit 2 is the staff memo dated August 18, 2021. Exhibits 3 through 5 pertain to affidavits of publication for public comment as docketed by Delmarva in December of 2020. Exhibits 6 through 8 pertain to the affidavits of publication for this evidentiary hearing as docketed by Delmarva in August of this year. The parties have conferred, and I am authorized to represent that the parties stipulate to the admission of the exhibits as set forth on the exhibit list. As such, I would like to move for the admission of the exhibit list into the record.
Any objections to adopting the exhibits as proposed?
No objection.
No objection.
I'm sorry, was that a no or someone else comment otherwise?
No, no objection from the DPA.
All right, very good. So the exhibits are admitted accordingly. Thank you.
Thank you, Acting Chair Gray. Next, I would like to present company witness Brian Talley to present testimony in support of the company's application. I ask that he please be sworn in.
Mr. Talley, please.
I am on.
Mr. Talley, this is the court reporter. Would you please spell your full name?
Sure. My name is Brian Talley. That's B-R-I-A-N. T as in Tom, A-L-L-E-Y.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Can you please again state your full name for the record?
Yes, Brian Talley.
And Mr. Talley, by whom are you employed?
I'm employed by PHI Service Company, primarily on behalf of Delmarva Power. My business address is 500 North Wakefield Drive, Newark, Delaware, 19702.
And in what capacity are you employed by the PHI Service Company?
I am the manager of revenue requirements.
Can you please tell the Commission how long you've been in this position?
I've been in this specific role for 5 years, and I've been with the family of Exelon companies for over 15 years in various accounting, finance, and regulatory roles.
And what is your educational background?
I hold a Bachelor's of Science in Accounting and a Master's in Business Administration from the University of Delaware, and I'm also a licensed CPA.
And were you involved in the preparation of the filing in this docket that was submitted to the Commission?
Yes, I'm primarily responsible for this filing.
And can you briefly explain the purpose of this filing? Yes.
The purpose of this filing is to apply for a change to the rider EE surcharge rate for year 2 pursuant to Order 9453 in docket 17093. These revised rates will be effective for the period January 1st, 2021 to December 31st, 2021, and include estimates for the projected period plus prior period true-ups for over or under recovered balances.
Mr. Talley, can you just clarify what docket order number 9453 was from?
If this filing was associated with revised tariff sheets, energy efficiency.
Sorry, Mr. Talley. I think you maybe misstated the docket number in your previous response, so I just want to clarify which docket number order number 9453 was from.
I believe it was from docket 17-0935. I'm not sure what I said previously, but that's okay.
Didn't mean to.
Wasn't sure which way around.
Okay, and can you please explain to the Commission what the filing was composed of?
sure, maybe I jumped ahead. The filing was composed of revised tariff sheets, energy efficiency charge calculations, rate charge percent, and supporting work papers. The calculation was consistent with the company's original filing.
Thank you. And what was the rate that Delmarva calculated for the year two EE rider rate?
Delmarva calculated, as you mentioned before, as 0.000828 per kilowatt hour for the classification R, RSH, R-TOU-ND, and PIV service classifications.
Thank you. Can you please describe the customer impacts associated with the year two EE rider rate?
Yes. As set forth in the application, the monthly bill impacts will cause the average increase of approximately 0.38 or 38 cents for an increase of 0.31% for a typical residential non-space heating customer using 845 kilowatt hours on an annual average basis. To be clear, should the Commission elect to enter the proposed order number 9866, the rates currently in effect would not change, it would not increase any further.
And in connection with this filing, did you meet with PSC staff and DPA to review the documents associated with the filing?
Yes, several formal and informal meetings and discussions occurred with PSC staff and DPA before and after the company's filing.
And did the PSC staff or the DPA propose any adjustments or modifications based on the documentation included in the filing?
No, neither staff nor DPA proposed any adjustments or modifications.
Was notice of this application published as required by Order 9694?
Yes, pursuant to Order Number 9694, Delmarva published public notice for proposed EE rider rate on or before December 18th, 2020.
And were the affidavits of publication filed with the Public Service Commission?
Yes, those affidavits of publication were docketed on December 28th, 2020.
And likewise, was notice of the application published in connection with this evidentiary hearing?
Yes, Delmarva published public notice for this evidentiary hearing on August 3rd and 4th, 2021.
And were those affidavits of publication filed with the DPSC?
Yes, those affidavits of publication were docketed on August 25th, 2021.
And are the rates currently in effect?
Yes, these charge rates were put into effect on a temporary basis effectively January 1st, 2021.
And did staff provide an opinion as to whether the Commission should approve as final the rates that went into effect on a temporary basis?
Yes, staff's August 18th, 2021 memo recommends that the Commission approve as final the 2021 EE rider rate that went into effect on a temporary basis on January 1st, 2021 with proration for the period January 1st, 2021 to December 31st, 2021.
Thank you. And does this conclude your testimony, Mr. Kelly?
Yes, it does.
Thank you. And Delmarva hereby offers Mr. Kelly for cross-examination.
No questions.
No questions.
Thank you. Thank you very much. I think Mr. O'Brien is representing staff on this matter.
Yes, Acting Chair Gray. If that was Delmarva's last witness, I will proceed. This is Bill O'Brien, Deputy Attorney General, counsel for staff in this matter. Thank you, Acting Chair Gray and Commissioners. Staff does have one witness to call today, Amy Willie. So I would ask the court reporter to swear her in.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Willie, if you can put the microphone closer to you, it may be helpful. It's we can't hear you very well.
Yes. Is that better?
That is better. Let's move through this. Please state your name and address.
My name is Amy Willie. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
What is your current employer and what is your position title?
I am employed by the Delaware Public Service Commission as a public utility analyst.
And what is your educational and professional background?
I have earned a Bachelor of Science degree in Business Management from Wilmington University. I have been employed with the Public Service Commission for over 2 years as a public utility analyst. I also have 12 years prior contract sales experience, which included but was not limited to the analysis and preparation of various financial documents.
And what was your role in this docket?
I was the case manager for the 2021 Energy Efficiency Surcharge Rider Rate and reviewed the application and the supporting documents.
All right, I'm going to skip over the question about what this proceeding is about since Delmarva covered that. Did staff receive any public comments pertaining to this application?
No, staff did not.
And what was the nature of your review?
I reviewed calculations, invoices, and worksheets comprising the development and summation of the 2021 Energy Efficiency Surcharge Rider Rate. I also reviewed the settlement agreement approved by the Commission in Order 9453 in the PSC docket number 17-0985. In that settlement agreement, the Commission approved certain energy efficiency programs and approved Delmarva's recovery of the cost of the approved programs through a surcharge that would be applied to Delmarva's R, RSH, and RTOU rate classes.
What did you find as part of your analysis?
After reviewing a significant amount of documentation for accuracy and compliance with the settlement agreement in PSC docket 17-0985, I found no substantive errors.
And what's the monthly bill impact of the proposed energy efficiency surcharge? Now, we realize that the rate's already in effect on a temporary basis, but, versus prior to that temporary rate going into effect, what is the bill impact?
The bill impact of approximately 0.38, or an increase of 0.31%, is for a typical residential non-space heating customer using 845 kilowatt hours on an annual average basis.
And what are your recommendations?
Staff respectfully recommends that the Commission approve as final the 2021 Energy Efficiency Surcharge Rider Rate that went into effect on a temporary basis January 1st, 2021, with proration for the period from January 1, 2021 to December 31st, 2021.
And do you believe your recommendations will result in rates that are just and reasonable and in the public interest?
Yes, I do.
And does this conclude your testimony?
Yes, it does.
Ms. Willie is available for cross-examination.
No question.
Any questions? Okay.
No question.
And that is staff's final witness. Thank you.
Thank you very much, Mr. O'Brien, Ms. Willie. Does the DPA have a statement to make in this matter or witness?
Thank you, Acting Chairman Gray. The DPA does not have a witness. We do support the proposed form of order and the proposed rates. We thank Delmarva for for meeting with us and walking us through the application and explaining how they got to the proposed rates, and we're satisfied with the proposed rates. Thank you.
Thank you, Ms. Iori. If commissioners have any questions or concerns with regard to this matter? Could I please get a motion to adopt order number 9866, please?
So moved. I second the motion.
Thank you very much. It's been moved and seconded to adopt order number 9866. Any further questions or conversation? Hearing none. Commissioner Correa, how do you vote?
Aye.
Commissioner Drexler?
Aye.
And I also vote aye. Thank you very much to the parties for the presentation to the commission. I think that the next item on our agenda are administrative matters, so I'll yield to Mr. Harding.
Thank you, Acting Chairman Gray. I just wanted to mention that our next meeting is Wednesday, September 15th. I also wanted to ask Jenny Board to update the commission regarding our SOS technical consultant.
Good afternoon, Acting Chair Gray and Commissioners. This is Jenny Board. Can you hear me?
I can.
Yes, I can.
Thank you. As
I
you are-
can. You're okay?
Thank you. As you're already aware, the Commission utilizes a technical monitoring consultant in the standard offer service procurement process. The consultant's contract is for 2 years with a 1-year option to renew. The consultant is approved by the Commission. This year, a request for proposal, or RFP, was issued by Delmarva in June. 3 consulting firms responded. All proposals received were reviewed by staff, and all bidders have experience in utility procurements of electricity, and are familiar with PJM's markets. Staff has submitted a memo on its review of the responses to the RFP and would like the Commissioners to give staff guidance on its selection. Should you wish to discuss the bid prices, you can enter into an executive session to ensure the confidentiality of the prices. And I'm happy to answer any questions that you may have.
All right, thank you very much. Does any commissioner want to move into an executive session for a conversation on this matter? I don't hear a desire to move to executive session. Could I perhaps get a motion from one of the commissioners for the contract recommended by staff?
I move that we adopt the contract recommended by the staff.
Do I hear a second?
Mr. Acting Chair, is it possible at this point to move into executive session to discuss this further?
Well, there has been no second to Commissioner Correa's motion, so I think procedurally, if you were to submit a motion to go into executive session, we could then take a vote.
Yes, I would like to make a motion to convene an executive session at this time.
Yes, I second it.
For purposes of discussing trade secrets, commercial financial information, and a decision required. We will come back into a general session before taking a vote on this matter. So it's been moved and seconded. Any further questions or concerns from the commission? All right. Commissioner Correa, how do you vote?
Yes. Vote aye.
Commissioner Drexler?
Aye.
And I also vote aye. And just a point of order here before we actually go into executive session, I just want to announce that we will go into executive session for this conversation, then we will convene in a general session. I unfortunately need to request from the executive director, Mr. Hartigan, what number can we call for this executive discussion?
This is Bill O'Brien. Mr. Hartigan, I'm wondering if you could send it to them by email.
Yes.
Yeah, sorry.
Yes.
Thank you very much.
Okay.
So we will convene as soon as we receive the information from Mr. Hartigan. We will dial in and convene the executive session, and then we will reconvene the general session after we have that conversation. Thank you.
Thank you.
Hi, this is Pam Knotts.
Hey, Pam. Just sending this email now.
Hey, it's Bill.
So Matt, this is the number, right?
Yes, it is.
Okay, thank you.
the phone that is connected to the regular meeting, just so they don't overhear us speaking in executive session.
Yeah, we've done that.
Oh, okay.
So I just sent the email, so hopefully Commissioner Gray and Drexler will join us.
Thank you, Mr. O'Brien.
And I guess it goes without saying too, Matt and Bill, that if the commissioners are on two different phones, that the one for the streaming or the, commission meeting needs to be muted.
Yes, thanks. Doing that now.